Hey, everybody. Welcome. Come on in, make yourselves at home. Welcome to the Law Self-Defense Show for the second time today, Tuesday, March 29th, 2020. Today, we're going to talk about the case of Michael Barisone. All right, come on in, everybody. So, Michael Barisone. And let's get a little facts in order on this case as they've been reported. Certainly, Michael Barisone is not looking too good these days, just from a demeanor perspective. So, who is Michael Barisone? Well, he's the owner of an equestrian center, a horse farm training facility. Barisone himself was an Olympian horse rider. In a particular area, I guess dressage is a form of horse riding. And that was long ago. Now he's 57 years old, happens to be my age, as a matter of fact. And he took on board a young woman as a trainee in dressage, Lauren Canreck. And Canreck, well, I guess she wasn't a young woman after all. I thought she was. Interesting. 41 years old. That feels a little old to me to be training for the Olympics, even if you're riding a horse. But regardless, Canreck and a gentleman who is sometimes described as her boyfriend, sometimes her fiance, both lived in a house on Barisone's farm. So Barisone had made arrangements with Lauren Canreck to live in a home on the farm property. Apparently, those arrangements were in part arranged through Canreck's father, even though Canreck is well an adult. So we have Canreck, her boyfriend / fiance, Rob Goodwin, and the father lurking in the background here. Canreck and the boyfriend are living in a home on the farm. And the relationship between Canreck and Goodwin on the one hand, the tenants in the home, and Michael Barisone himself became extremely toxic. And frankly, it sounds like, to me, like Michael Barisone may have been borderline in terms of emotional stability to start with. And then he ran into this couple that appears to me to be extremely toxic in their behavior. There was all kinds of vicious mind games being played, buttons being pushed, social media castigations, insults, allegations against Michael Barisone, which apparently have no founding in fact, of Barisone sexually molesting the 11-year-old son of Barisone's own girlfriend. The girlfriend and the son lived with him in his home on the farm. So an extremely hostile and toxic relationship that led Barisone ultimately throughout the summer of 2019 to call the police numerous times, complaining about Lauren Canreck and her fiance, telling the police he was in fear for his life. The police would show up, and there wasn't any actual physical threat apparent to Barisone. He was just being kind of mentally and emotionally tortured by this couple, if you believe the defense. But there was no actual violence or threat of violence for the police to respond to. So although the police responded repeatedly, there were at least 6 911 calls placed to the police just in the week prior to the shooting. The police essentially told Barisone, look, this is a civil issue. You're trying to get this woman off your property. She lives there. You invited her to live there. She's a tenant. If you want to get her out of her house, that you let her use, there's an eviction process for that. For those of you who don't know, the eviction process can commonly take months, is almost impossible. Ironically enough, apparently Lauren Canreck had complained to local town officials about Michael Barisone, claiming that his home was in disrepair, that his barn was in disrepair, that the clubhouse on the horse farm was in disrepair to the point of violating codes. And the town came out and essentially concluded that all that was true. And announced to Barisone that none of those structures were fit for human occupation. So she effectively got him kicked out of his own house. He was ultimately sleeping on a mattress on the front porch of his home, believe it or not. Ironically enough, although Canreck made those complaints to town officials and they came out and shut down many of the structures on the farm, including Barisone's own home, the person doing that work, that unlicensed, unpermitted, code-violating work, was actually Canreck's fiance / boyfriend, Rob Goodwin. So we can see this is just a poop fest of interrelationship going on here. And it all culminates on August 7th, 2018. On that day, Barisone would say he approached Canreck and Goodwin and said, "Hey, listen, can't we just work this out? I don't want a war between us." Canreck basically told him, "You can go screw. By the way, I'm accusing you of sexually molesting the 11-year-old son of your living girlfriend." And from that moment, Barisone would say he completely lost all recollection of what happened after that point until he would later regain recollection in the hospital where he would end up, which is unfortunate because what actually happened here was, Canreck had actually approached the boyfriend, Goodwin, said, "Can't we all get along? I don't want a war." The boyfriend said, "Listen, it's past that now. We're going to settle this with the lawyers." Goodwin turned and walked away from Barisone, but the girlfriend or fiance, Lauren Canreck, pushed past her boyfriend, approached Barisone, and hurled more hate at him. She had been posting vile things about him extensively on social media, which he was aware of. She had apparently been recording his private conversations and sharing that on social media, of which he was aware. She hurled more, apparently, hate at Barisone, and Barisone took a gun out of his pocket and shot her twice in the chest. She would survive those injuries, but they would be the basis for attempted murder charges against him. And he would fire a shot at the boyfriend as well, and that would be another count of attempted murder brought against him. So he would then end up at the hospital. The police were called. When the police arrived, the boyfriend Goodwin pointed at Barisone as the shooter, which she was, and he was promptly arrested, held without bail, and now his trial has begun on those attempted murder charges. So yesterday we had the opening statements in the case from the defense, about 20 minutes of opening statement. From the state, about 20 minutes of opening statement. From the defense, about 40 minutes of opening statement. And that's what we're going to work our way through today. So in some respects, this could be characterized as a self-defense trial. There is a sliver of the defense opening statement that suggests self-defense. The defense attorney says that Barisone was beaten by Goodwin, that he was attacked viciously by the dog owned by Canreck and Goodwin, and doesn't really say, but hints that maybe that's why Barisone fired the shots into Lauren Canreck and at the boyfriend Goodwin. But it's really just a sliver of the opening of the defense. When we listen to the entirety of the opening of the defense, it's largely a narrative in which the defense is trying to convince the jury that they should not find his client guilty because he was the victim of a campaign of emotional and psychiatric destruction wrought by the victims in this case, Lauren Canreck and Goodwin and Lauren Canreck's father. That's the picture he's trying to paint for the jury. But of course, even if true, that's not a justification for the use of force. It's not a self-defense justification for the Barisone's use of force against Lauren Canreck and her boyfriend / fiance Goodwin. It could be the basis for an insanity defense, but insanity is a tough defense, folks. The standard is very, very, very high. Essentially, you have to not know that what you're doing is wrong. You have to be in such a psychiatric state of disorder that you believe the thing you're shooting is a space alien. It's not a human being. It's a space alien sent to take over the world. You have no recognition, no understanding that you're actually shooting a human being. Therefore, you wouldn't know that you were committing the wrong of shooting a human being. Here, there would appear to be no question that Barisone knew he was shooting at human beings when he fired his gun. So insanity would certainly appear to be a stretch. I do know that the defense plans to call psychiatrists and a psychologist as expert witnesses. The defense would like to introduce lots of evidence about email and text exchanges between Lauren Canreck and her boyfriend Goodwin and Canreck's father, in which they apparently chortle about their, it appears, effective efforts to drive this guy, Michael Barisone, around the bend, I should say. It seems they were deliberately trying to drive him nuts. And ultimately, they succeeded. I'm not sure they would say they were particularly pleased with the outcome. But that is where we find ourselves with these opening statements. So it's a couple counts of attempted murder in this case. So let me see. I had a little challenge earlier with pulling up some video. Let's see if we can get to this today. So I have not heard the state's opening statement. I didn't have time to listen to it. I did listen to the defense opening statement, so I'm somewhat familiar with that. But the state opening statement will be as surprising to me, or blank to me, or I'm as naive to that opening statement as all of you presumably are. And let's see if I can pull that up. Open that file. Okay. It looks like I should be. Okay. I don't know yet, so I don't want to say yet. Okay, so that should be working. So let's start with the state opening statement. Before I do that, let me jump into, again, folks, I'm happy to answer all your comments throughout. I'm just going to pull up the Law of Self-Defense member feed to make sure that's working okay. And we should be on Rumble as well. There we go with that. And for those of you who were not with us this morning, we did do a live show this morning on the on both the Oscars, the Oscar slap of Will Smith slapping Chris Rock, as well as, okay, so that's working on the membership page, as well as the okay. So the Rumble should be working as well, I think. See if that spools up. Indeed, it is. Wow, I'm becoming a technology maven at this stuff. So before we jump into the actual video of the state's opening, going to take a quick look here at the super chats on YouTube. Looks like we are, let's see, clear so far. Of course, if you're a Law of Self-Defense member, I encourage you to put your comment on the Law of Self-Defense chat message, member dashboard, and those always get priority. If you're on YouTube, you need to make it a super chat in order for me to be able to answer it. I know the beard. It's in fact, I think just a few minutes before I started this live broadcast, Amazon delivered a beer maintenance kit. So there we go. Yeah, so this is not a good look for Michael Barisone. He didn't look like that at the time. He looked like, let me pull up this other image here. He looked like this. So a bit, how can I put it? A bit better kept, more normal. And now he looks in court yesterday and presumably also today. He looks like, what happened? He looks like this. So much the worse for wear. And as we watch the opening, the camera in the courtroom will occasionally pan to defendant Michael Barisone, and he just is acting like a lunatic. He's grimacing, making bizarre facial gestures. He's kind of rocking around, darting his eyes around. Perhaps it's all a charade. Perhaps he's just profoundly a broken human being. We obviously can't see into his head to the extent that his defense attorney wants to go for a some kind of insanity defense. Um, looking crazy in the courtroom is not going to help. I mean, the real question, of course, is whether he was crazy at the time, but he's certainly looking crazy at the moment. And also, it's quite possible, folks, that the lawyers maybe he figures insanity defense is a stretch goal here, perhaps not realistic. But why not try? But he may also be looking for some kind of compromise verdict. For example, there is a doctrine called imperfect self-defense. Imperfect self-defense can occur under a variety of circumstances. It's generally when you don't qualify for perfect self-defense, for normal self-defense, because there's some profound defect in your claim of self-defense. Often, that defect is that you had a genuine subjective belief in the need to use deadly force in self-defense, but that belief was not objectively reasonable. It was irrational in some respect. Because perfect self-defense that would lead to an acquittal requires both subjective and objective reasonableness. If your use of defensive force was objectively unreasonable, it can't have been perfect self-defense. You can't get an acquittal on the basis of self-defense. But what can sometimes happen is you can qualify for what's called imperfect self-defense. So that cannot lead to an acquittal because it's not perfect self-defense. But in essence, imperfect self-defense would normally hold that if you've killed someone in the subjective, genuine, good faith belief that you needed to do that in self-defense, but that belief was irrational, unreasonable, you lose perfect self-defense, but you can still have imperfect self-defense. And under imperfect self-defense, what would have been a murder conviction gets mitigated to a manslaughter conviction. So here we have we don't have a murder charge because neither of the victims died. We have attempted murder charges, and the notion that attempted murder would be mitigated to attempted manslaughter. First of all, it's hard to understand how attempted manslaughter would be a thing because manslaughter is either reckless, so it's not intentional in the first place, the killing, or it involves what the law would call sufficient provocation, an emotional state that strips you of the intent to cause the death, or is deemed to have stripped you of the intent to cause the death. The classic example is a spouse who comes home and finds their spouse in bed with a lover and kills them both in a rage. Again, the intent part is gone there. So it's hard to understand how that mitigation of imperfect self-defense would apply in inchoate circumstances like an attempt crime, attempted manslaughter, attempted murder here, rather. Or the defense attorney may just be trying for some kind of emotional compromise verdict. Remember, jurors don't explain how they arrive at a verdict. We tell them, the judge tells them they are to apply the law as they are instructed by the court, whether they like that law or not. But sometimes jurors, the jury can be split, and some jurors want to convict and some want to acquit. And they'll say, all right, well, you want murder and I won't go for murder, so let's pick something in the middle like manslaughter. That can happen too. If the jury's been instructed on lesser included that they might be willing to compromise on. Now, that compromise could be completely irrational from a legal perspective. But again, a jury doesn't have to explain how they arrive at a verdict. So that can and does happen. Let's see. Well, thank you, Admiral Veer 85 for the super chat contribution. He writes, Branko, with the beard, you look like Gersh Kuntzman. Are you traumatized by AR-15 recoil? So I actually don't know who Gersh Kuntzman is. I do recall the news reports of a journalist who fired AR-15 at an indoor range and declared himself traumatized as a result. Yeah, I'm definitely not traumatized by firing an AR-15. Maybe if an AR-15 was fired at me, that sounds like it would be traumatic. Fortunately, that's never happened. Firing an AR is nothing but pure joy as far as this small town lawyer is concerned. It's why I have my fair share of them. All right, so let me start this opening. Again, I've not seen the state's opening statement, so I am as naive to it as you are. I'll try to keep the pauses and my interjections as limited as possible so that we don't overinvest the day into all this. But of course, when I think there's something worth saying, I'll jump in. If you, again, want to make a comment on the Super Chat, that's absolutely fine. In fact, it's encouraged. And I'll be sure to answer those as seems appropriate. Okay, so here we go with the opening.
All right, be seated, everyone. Thank you, members of the jury.
Oh, I will caution that this judge, like in the Curtis Reeves case, we have another pen clicker here. And not only is he a pen clicker, he's a paper rustler. And apparently he does all this within 2 inches of his microphone. So it frankly drowns out the lawyers. So I did do some audio optimization for these videos to help improve our ability to understand what the lawyers are actually saying and not let it be drowned out by pen clicking and paper rustling. I would apologize for all that, except it wasn't me. It was the judge. So here we go.
We are ready to commence with the trial, beginning with opening statements. Mr. Shellhorn.
Thank you, Judge. May it please the court, counsel, members of the jury. Good morning. Thank you again all for being here today and for serving on the jury. 411 West Mill Road is an equestrian farm, a 50-acre equestrian farm and training facility located in Washington Township, New Jersey. When you turn from West Mill Road onto the property.
All right, it's already a bad start by the state. This is already boring. You don't start your opening statement with the address of the scene where the event occurs. You need to humanize what happened, your narrative of what happened immediately. We are here because this defendant brutally shot 2 innocent people. That's what you need to say to start. You don't start with a damn address. Jeepers. Of course, this lawyer looks like he's about 12, so maybe that's what's at issue. You'll notice when we get to the defense opening that that's the lead defense attorney there on the left on the screen, sitting down next to the defendant. Notice the defendant's weird facial gestures, by the way. That happens throughout. But you'll notice when the defense attorney there on the left gets up to give his opening statement, he makes it emotional from the beginning, an emotional connection with the jury, which is the smart play. Of course, he looks like he's probably much more experienced. Before I start up, I see a super chat here from Pincalo, the driving ape. I guess he's asking about the AR-15 traumatization scenario. He asks, what if you were in the gallery and Binder, I guess Binger, was prosecuting? If you recall, Binger famously pointed the AR rifle in the Kyle Rittenhouse case at the jury, or at least he appeared to do so on camera. I've heard it disputed whether or not he actually muzzled the jury. I would be extraordinarily unhappy to be muzzled by any firearm, particularly a long gun in the hands of a prosecutor who apparently knows nothing about firearms. I would have made my displeasure known to the court instantly and loudly. C. Neal, thank you for the super chat contribution. He asks, did you enjoy Fredericksburg and did you make it to Wimberley on your trip? This would be my trip through Texas Hill Country. Neil, I hit virtually all of Texas Hill Country. I don't recall going through a town called Wimberley, however. Fredericksburg was fantastic. Really liked it. I'll be there again. That that Museum of the War in the Pacific was just fantastic. Great restaurants. I recommend Fredericksburg to anybody who is passing through that area of Texas or looking for a nice part of Texas to visit for sure. Okay, let's get back to the video.
There's a long driveway that goes back almost directly through the center of the property. The first thing you see on your left is a white farmhouse that's been subdivided into several smaller living areas that are interconnected, but basically separate areas for people to live. And behind the farmhouse there's a parking lot or a little driveway. And as you continue up the long driveway through the middle of the property, it comes to a slight rise, and then it descends down into a parking area where you can see the real reason that people come to this property, this farm that's sometimes known as Hawthorne Hill. And that's a training facility there. It's an equestrian training facility. To the right, there's a long stable with a number of stalls for dozens of horses. There are outdoor training arenas and fields for the horses to go through their training and for the riders to learn and train. Connected to the stable through a hallway is a locker area with various different equestrian materials and equipment, saddles, things of that nature. And then that leads into what's called the clubhouse. Now, if you take a step back out to the parking lot, you can also get into the clubhouse through a large front porch, and then you walk through an opening and an entranceway, and then you come into this clubhouse, which is basically like a long lounge. It's almost the entire width of the building. It has a kitchen on the right, a long table, a row of walls. The entire wall is glass.
Okay, another criticism. Either all this description of the layout of these buildings and their rooms and the hallways, either this is important or it's not important. And if it's not important, we ought not be talking about it. And if it is important, he ought to have a demonstrative illustration of all this. This kind of thing, it's impossible to effectively describe this kind of information as physical geography of the farm and the structures of the buildings verbally in a way that will be useful to jurors who've never seen it and never been there. You need a poster board with a diagram that you can point to. If this is all important, you need to do that. You need to communicate that information effectively in a way that the jury can understand and retain it and apply it to their deliberations, to their perception of the evidence over the course of the trial. You can't just describe it verbally. And if it's not important, why are we wasting time talking about it, especially in the first introductory portion of your opening statement?
And it looks out onto an indoor training arena. There are comfortable couches, chairs, things of that nature. There's a pool table. Off to the left, there's a small office to the side. And you'll notice when you see some of the pictures during the course of the trial that the walls all have various photos and pictures of horses and other equestrian related things. There's also a number of awards, ribbons, medals, many of them earned and awarded to the defendant in the trial, Michael Barisone. Now, I expect you'll learn during the course of the trial that the defendant was an accomplished equestrian. He trained and rode in a form of equestrian called dressage, which for those of you who may not be familiar of it, you may have only seen it once or twice in the Olympics. It's a form of horse riding where the rider guides or directs the horse through a series of predetermined specific motions or steps.
I would love to know why the details of dressage are important to the legal issues in this case. It's unimaginable to me. Again, I simply don't understand why this guy simply doesn't describe this in passing as horse riding or training in horse riding. Does the jury need to know what dressage is?
You can imagine it takes great skill for the rider to be able to guide the horse through those predetermined steps or movements, but it also takes a great deal of training for the horse to learn those things and to be able to do that. And you'll hear about how the defendant operated his business, Barisone Dressage, not just at that property in Long Valley, but also at another property that he owned in Loxahatchee, Florida. And generally during the course of the year, he and his people that he was working with and the horses that he was working with would train down south in Florida during the winter months when it was too cold to train in New Jersey. And then they would come north in the summer when it was too hot to train in Florida. I expect you'll learn that the defendant, Michael Barisone, ran that business for a number of years, and that he had other people who worked with him at times, specifically a man named Justin Hardin, who was his assistant trainer and did a lot of the day-to-day, taking care of the property and the farm during the course of a day, making sure that the arenas were all groomed properly. There were a number of us working students who would work and live at the farms, and they would take care of the horses and again, take care of some of the more day-to-day things. But the defendant was really the reason that people came to that business because of his success. He had ridden at the highest levels of dressage. He had coached other athletes at the highest levels of dressage. And he had also coached a number of horses and trained a number of horses throughout the course of his career. Now, I'm sure you can all imagine, we didn't ask you all to step away from your lives. We didn't put you through jury service last week. We didn't ask you to come back here and sit on this trial for the next number of weeks, just to celebrate the defendant and to hear about his accomplishments as an equestrian, as a coach, as a businessman.
So now we're 5 minutes in to the state's opening statement. And now, for the first time, he's going to tell the jury why they're here. I guess that's one way to go.
We asked you to serve on this jury because of what the defendant is accused of doing at that property on August 7th, 2019.
Hey, folks, if you could, please, I see someone mentioned in the comments, thank you for reminding me. I'm so terrible at this stuff. But if you're watching, particularly on YouTube, if you could pound that subscribe button, it's free. And we're within less than 200 people of hitting 30,000 subscribers. So it would be awesome to get pushed over that. You need to be a subscriber to comment anyway. So if you're watching without being a subscriber, please hit that button. You'll get the commenting privileges as well. Also, if you hit like, and to the extent you comment, that also helps fool the YouTube algorithm into spreading word of all this. By the way, folks, my the video I did this morning for about an hour on the Oscar slap and the Chicago Transit Authority shooting, I included in that about 45 seconds of the Oscar slap, and YouTube has notified me that Fox Sports News, for some bizarre reason, has claimed copyright of that 45 seconds, and they've demonetized the entire hour of this morning's show. So that's nice. Frankly, if that kind of stuff keeps up, it's pointless for me to put content on YouTube at all. But that's the way that goes. So I don't know, maybe I'll get treated better by YouTube if I have a higher, more of a Nick Rekieta law subscriber count. Can't hurt, right? So if you can subscribe, hit like, comment, let friends and family know about this channel. They can always find it at lawselfdefense.com/YouTube. That would always be appreciated. Okay, yeah, and click the bell. Don't forget about the bell. So in theory, YouTube will send you notifications of when we schedule these live shows or post up recorded content as well. All right, so why are we here?
On August 7th, 2019, he's accused of taking a gun, leaving that clubhouse that I talked about, getting into his car in the parking lot, driving up the driveway over that slight rise, coming into the back parking lot where the farmhouse is, getting out with that gun, which is really the pink and black 9mm ammo, confronting two people who were living in the farmhouse.
All that paper rustling is the judge, believe it or not. That's the judge making that noise.
The gun at the woman, Lauren Canreck, and shooting her twice in the chest. Then turning the gun on Robert Goodwin, her boyfriend, as he fled into the house and shooting another shot at Robert, but missing. That's the purpose of why we're here for this trial. Now, I'll pause for a moment just to mention that I'm not going to tell you every detail about this case during the course of my opening. There are things that I'm intentionally leaving out, and that's because of something the judge told you last week during jury selection, something he told you this morning, and he'll tell you that again, I'm sure, at least one more time before the trial is over. What I say, what Mr. Belinkis may say, is not evidence. The evidence doesn't come from the attorneys. It doesn't come from the judge. The evidence will come from that seat right there, the witness stand. The witnesses who come through that door take an oath to tell you the truth, and then any evidence that the judge allows to be admitted. So if I'm leaving certain things out, that's intentional at this point, because the purpose of my opening is just to give you something of a roadmap or some way of what you know what to expect is going to be coming with some of the other witnesses who testify.
That should be the second sentence of the opening. I'm speaking to you now to frame out our narrative of guilt so you can understand where the pieces of evidence fit in that narrative as you hear it presented here in court. The first sentence should be, why are we here? What's the humanity of this story? Why does this matter? Because 2 innocent people were shot by this defendant without justification. The second thing is, and my opening statement is going to frame out that narrative of guilt so you can understand how to place the evidence in it. And then you go in. You don't do this 6 or 7 minutes into your opening, folks.
Now, you heard me mention Lauren Canreck and Rob Goodwin, and they were living at the farm, as I said, during the summer of 2019. And I expect you'll come to learn that Lauren was also a rider. She was an equestrian who rode different forms of horses during the course of her life, but she at that time in her life was training for dressage, and she hoped that she would achieve a higher level of training. And so she wanted to work with the defendant because of his reputation. She owned a number of horses that she was stabling there, and as you can imagine, the best things in life are not free. So she was, of course, paying the defendant for the opportunity to work with him and to have her horses coached by him. And so you'll hear how she was doing that there, and at times she would work with Justin Harden, the defendant's other trainer, and at times she would work with the defendant's girlfriend, Mary Haskins-Greff. You'll come to hear how Mary Haskins was also being coached by the defendant. She had aspirations to reach these higher levels. Mary Haskins and the defendant also owned a number of horses together. And you'll hear that at times, Lauren was asked to work with Mary Haskins and to have Mary Haskins work with her. Now, as you can imagine, what I just told you about August 7th, 2019 didn't happen because the training was going well. It didn't happen because
All that scribbling noise, that's the judge that you can see behind the state prosecutor here. The judge is scribbling away like he's writing a hate letter to his ex-wife. It's unbelievable. Ugh.
because things between these people was all perfect. I think it's quite to the contrary. You're going to hear about how bad things were at Hawthorne Hill in August of 2019. You'll hear about how the defendant and his girlfriend, Mary Haskins, were hassling and giving a hard time to Lauren and Rob. And you'll hear how Lauren and Rob were giving a hard time back and hassling back to the defendant and Mary Haskins. You're going to hear how they were really arguing on an almost daily basis at that point. How the police had been called out to the property starting July 31st on almost a daily basis because these people just could not get along. You'll even hear about how not just the defendant and his girlfriend, Mary Haskins, but also Lauren and Rob were making complaints or reports up to the highest levels of the sport, the U.S. Equestrian Federation or Foundation and Safe Sport, which is an agency that you may have heard of that basically oversees Olympic level sports and tries to prevent abuse and misconduct by the coaches or the players or other people involved. So both of these groups of people have it in for one another, and they are making complaints against one another, and they are at odds. I mention all of that now in my opening because it's obviously part of the case. It's something you're going to hear from the witnesses. It's something you'll hear about. But it's important to remember something the judge told you last week, something he told you this morning, and something he'll tell you at the end of the trial. And that's that when you go back to deliberate and when you go you're asked to return a verdict, it will not be about Lauren Canreck. It will not be about Rob Goodwin. It will not be about Mary Haskins. It will not be about any other person except this man. This man, the defendant, is the one on trial. So you may hear things that you don't.
So this is this part, I guess, is important for the state prosecutor to emphasize, given the angle of attack the defense is likely to take. So the defense is going to want to tell a story about how these other people, the victims, Lauren Canreck and her boyfriend Wilson, and the father of Canreck, apparently deliberately engaged in a course of conduct intended to drive this defendant insane, and they were successful in doing so in an attempt to explain the defendant's bizarre behavior, maybe get some sympathy for him, maybe get the jury to believe that blame should be shared across the parties. So this prosecutor now is saying, hey, those other people, you may hear bad things about them, and they certainly will if the defense attorney has anything to say about it. But they're not on trial. Only this defendant is on trial.
Don't like about Lauren or Rob or Mary Haskins or any of these other people. But saying nasty things, misbehaving, if you want to call it that, none of that is a justification to get shot. None of it creates a necessity for that person to be killed. No, we're here on this trial because of the defendant's choice on August 7th, 2019. His choice to get a gun, a pink and black 9mm handgun, to point that gun at Lauren and pull the trigger twice, and then to turn it on Rob and pull the trigger again. Now, I imagine some of you are probably wondering about that pink and black handgun, and it's obviously an unusual description for a handgun.
Look at this defense attorney here on the left, the lead counsel. He'll give the opening statement for the defense. He's looking at this lawyer. He's looking at this prosecutor like he's a piece of dog poo on his shoe.
So you probably have some questions about where that handgun came from. Why did the defendant have it? And I hope and expect that during the course of the trial, you're going to find that out. There's another woman who owned horses at the defendant's farm, and her name is Ruth Cox.
Oh, so when he's talking about the gun there, folks, the pink and black gun, he's telling the jury, I hope you'll find out why the defendant has that gun. It's because this is New Jersey, and this defendant had not jumped through the hoops that New Jersey imposes for possession of that firearm. So he's charged not only with attempted murder, but also with a gun charge for having the gun, because that's what you get when you live in New Jersey. And as I probably mentioned earlier today, but maybe it was earlier this morning, I forget now, those of you who are of a certain age may recall the case of Bernie Getz in New York City, who was accosted by 4 Utes with sharpened screwdrivers, who committed an armed felony robbery of him on a subway, and he pulled out a small revolver and sent hot pieces of lead flying in their direction, paralyzed one of them. And then he fled the scene. And ultimately, he would turn himself in because his description was all over the news. And he was charged with a variety of use of force, criminal offenses, and the gun charge because he was not lawfully in possession of that gun in New York. He had applied for New York City permits to be in lawful possession of a gun, but of course, they had rejected him. And so he had the gun unlawfully, and he was acquitted by the jury of every use of force charge brought against him. But they did convict him of the gun charge. And so off to prison he went on the gun charge. No matter what happens to this defendant, even if the jury were to decide the shooting was lawful, I expect he will still be convicted on the gun charge because it's a walk-away conviction for the prosecution. It's basically a possession charge. And he was indisputably in possession of the gun under circumstances where he did not have the needed permission from the government of New Jersey to be in possession of that gun.
And Ruth Cox is a resident of North Carolina. You're going to hear how she owned horses with the defendant. She owned horses with his girlfriend, Mary Haskins, and how she would travel north to New Jersey every couple of weeks to check on the horses. She would travel south to Florida during the winter months to check on the horses. She would go to horse shows and see how the horse was competing. And you'll hear how she got here to New Jersey, to the farm, on about August 2nd, so several days before the shooting incident. I expect you'll hear that at some point between then and the day of the shooting, she was alone with the defendant in the stables, and he asked her for her gun, which was a pink and black 9mm handgun. I expect you'll hear that she gave him that handgun, that it was in the case, that it was unloaded, and that she gave him that handgun and didn't see it again until after the shooting happened. I also expect you'll hear that Dr. Cox.
So that's how it happened. There was somebody visiting this horse farm that came from free America and brought a gun with them, a woman. That's why I guess the gun was pink, presumably. A woman from Florida was visiting the farm, had brought a gun with her to New Jersey. Folks, I would recommend against bringing guns into New Jersey. Contrary to New Jersey law, New Jersey is like New York and Illinois and Massachusetts. They will crucify you for unlawful possession of a firearm. But nevertheless, so it's not even a case where this horse farm owner had acquired the gun years before and was in long-standing possession. He was probably in rather transitory possession because the crisis between him and these other people on his property was coming to the culmination point. And he stated many times prior to the shooting to police he was in fear for his life, and that's probably why he armed himself with this Floridian's gun.
Ruth Cox was charged with a crime as a result of that she was charged with unlawful transfer of a firearm. So that brings me back to August 7th, the day of the shooting.
So the woman who brought the gun was charged with her own gun crime in New Jersey, unlawful transfer, because of course they didn't put the transfer through an FFL in New Jersey. Gotta love it.
What led to the shooting on that day at that time? If things were so bad between these people, why did the shooting happen on August 7th? Well, I expect you'll hear that a caseworker from the Division of Child and Permanency and Protection, sometimes called DCPP or DIFUS or Child Services, came to the farm in that early afternoon as a result of the complaint that had been made to Safe Sport. I expect you'll hear that the caseworker pulled down that long driveway, that she pulled into that parking lot, and the very first person that she met outside the clubhouse or the stable was the defendant. She didn't tell him anything about why she was there, just that she needed to speak with Mary Haskins, the defendant's girlfriend. That's because the defendant's girlfriend, Mary Haskins, had two children who would occasionally live at the farm or come stay at the farm if they were on a break from school or something else. The caseworker, Mary Haskins, then went into the office that I described inside of that clubhouse, and they were meeting in there. And I expect you'll hear that the defendant came in and interrupted them. First once, then a second time. And the third time he interrupted them, he told the two women that he needed the office, that they needed to continue their conversation in another part of the property. And so they left the office and left him alone in that office. That office is where the defendant's gun safe was. And I expect you'll hear that after the shooting, when the police were investigating and to search the property, on the top shelf of that safe, they found a black and pink gun case, the same gun case that Ruth Cox had given the gun to the defendant in. I expect you'll also hear that on the shelf below it, there was an open box of 9mm ammunition that was also open with a number of bullets missing. So after the caseworker and Mary Haskins left the office and the defendant was alone in the office, it was shortly after that he got into his car in the parking lot. He drove that truck up over the rise on the driveway and pulled into that parking lot behind the farmhouse, where he knew that Lauren and Rob were. I expect the evidence will show that Rob first spoke with the defendant while Rob was standing on the porch, and that there's a large bush next to the doorway area, such that Rob really couldn't see anything from below the defendant's chest or so. And that he, the defendant, said words something to the effect of, "How do we end this without a war?" I expect you'll hear that Lauren then came out of the house, or Lauren was walking down the steps of the porch, and that's when the defendant pulled out the gun and shot her twice, puncturing her lung, causing massive internal bleeding, life-threatening injuries that she was fortunate enough to survive. And that's why this is an attempted murder case. You'll hear that Rob was able to subdue the defendant and hold him on the ground until the police got there, because Lauren was able to call 911 after she had been shot. Again, there are many details that I'm leaving out. This is just a rough sketch of what I expect you'll hear during the trial, but hopefully it gives you an idea of what to expect over the next couple of weeks. The last thing I want to mention before I sit down is the law. Now, hearing the evidence, hearing the facts would mean nothing to you if you didn't have law to apply it to. And I'm imagining that the way that this case will move and progress is going to dictate what law the judge gives you at the end of the trial. But I can tell you about two parts of the law that are interconnected that I virtually guarantee that the judge will tell you at the end of the trial. I have to say, if I say anything different from what the judge tells you at the end of the trial, as you know, he's the judge of the law. He gives you the law. It doesn't come from me. It doesn't come from Mr. Belinkis. It doesn't come from any witness who may testify. The law only comes from the judge. But I think it's important to highlight these two parts of the law now, so you have an idea of what to expect as you're hearing that testimony and hearing that evidence. The first thing is that the burden of proving the defendant guilty of those crimes, attempted murder and possession of a weapon for an unlawful purpose, that rests on the state. You recall Mr. Bennett and I introduced ourselves to you during jury selection last week. That is our burden to prove. That burden to prove him guilty will never shift to the defense. It's a heavy burden, as the judge said, beyond a reasonable doubt, but it doesn't mean beyond every doubt. And what I expect Mr. Bennett and I will do over the course of the next days and weeks is call witnesses and present you with evidence that will leave you firmly convinced that the defendant committed these crimes. Evidence that you can rely on to make your verdict without any passion, any sympathy, any prejudice, any of those things the judge mentioned, that your verdict will be based on the evidence that we produce. The second part of the law that I want to mention is connected to that. And that's about the two charges that the defendant is on trial for. Now, there are two victims, so there's two counts of each of these charges. But the first charge, possession of a weapon for an unlawful purpose, means that his possession, the defendant's possession of that pink and black 9mm handgun on August 7th was unlawful because he had an intention to use it or a purpose to use it unlawfully against Rob or against Lauren in shooting him. The other charge, attempted murder, requires Mr. Bennett and I to prove to you beyond a reasonable doubt that the defendant took a substantial step to cause their deaths. Now, if you remember back to jury selection last week, and I know for some of you that was a full week ago, some people mentioned that they like to watch crime procedurals on TV. Some people like the dramatization. Some people like the true life, the documentaries. But the one thing that everyone acknowledged was that the law on TV is not the same as it is in real life. And certainly the law can change and be different from state to state. So that's why Judge Taylor will give you the law at the end of the trial that applies here in New Jersey. I mention that because some of you may have had a preconception or a notion that murder or attempted murder requires evidence of planning or preparation or premeditation. But a person can commit even the most terrible crime under the influence of an impulse that impacts their restraint, that causes them to ignore that restraint, that may ordinarily stop them or prevent them from committing a crime, from committing murder. But in that moment of emotion, in that moment of impulse, they ignore the ability to tell the difference between right and wrong.
So this is all quite true. I mean, many people imagine that first-degree murder, intentional murder, requires some kind of premeditation. Certainly, premeditation would allow for an inference of intent if someone demonstrably planned out a killing, bought the duct tape and the chloroform and wrote out a plan and had a map, and all that kind of stuff is introduced into evidence so that they had planned out beforehand how to carry out this killing, this unlawful killing. Certainly premeditation is evidence of intent. But what's required under the law is not premeditation, but intent. Premeditation can help you get to intent, but intent can be formed in an instant. In fact, generally speaking, if you point a gun at someone and discharge it, you are presumed to intend the reasonably foreseeable outcome of your actions. And if you shoot someone, sometimes in self-defense circles, you'll hear instructors say, never say you intended to kill that person. Say you wanted to stop that person. We don't shoot to kill in self-defense. We shoot to stop in self-defense. And that's true. And that's advice you ought to follow. Really, when you're shooting in self-defense, at worst, you ought not care. I mean, the goal is not actually for the other person, for your aggressor to die. And frankly, I would argue that it's in your interest that they don't die. It's in your interest that they live. Because if they live, at worst, you're looking at maybe an attempted murder or aggravated battery charge. If they die, you're looking at murder or manslaughter. So the criminal liability you face is much greater if they die. It's also, if they die and it becomes a murder or manslaughter case, you're going to attract the attention of the most senior and experienced prosecutors in that office. Their careers are made on murder cases. They love at cocktail parties to talk about how many murder convictions they've gotten. So you become a real target of personal interest to them if you're involved in a killing. criminal charge. So for a variety of reasons, it's better for you if that other person doesn't die, consistent, of course, with your own safety. You need to survive the physical fight. So the first priority has to be the safety of yourself and others you have a duty to protect. But if consistent with that, you could simply neutralize the other person and not have them die. That's the way you would want to go. That said, even if your intent is only to stop and you have no interest in actually killing them, if you use deadly defensive force, it's reasonably foreseeable that they will suffer death as a result, and that's more than sufficient foundation for a murder conviction or a manslaughter conviction.
Ignore the ability to understand what they're doing and commit that act anyway. And so even though it may not have been an act that was preconceived or premeditated or planned out in great detail long before that, the person can still act with purpose. The last thing I want to mention about the law is connected to that as well. And that's that I expect the judge will tell you that you can infer a defendant's purpose was to take a life, was to kill, if that person used a deadly weapon, a handgun. Now, again, in this case, you'll be instructed a handgun is a deadly weapon. And I expect you to hear evidence that the defendant did use that deadly weapon against Lauren and against Rob. And so you can use that alone to infer that his intent was to cause death. I expect the evidence to show that on August 7th of 2019, the defendant was angry. He was furious, he was frustrated, he was upset. He was angry with Lauren and he was angry with Rob. He knew what he was doing when he went into that safe. He knew what he was doing when he loaded bullets into the gun. He knew what he was doing when he left the clubhouse, drove down that driveway, and pulled into the parking lot to confront them. And he most certainly knew what he was doing was wrong when he pointed the gun at them and tried to kill them. I'm sure that I'll have more to say at the end of the trial. I want to thank everyone for your attention this morning. Thank you all for being here. I appreciate it. And at the end of the trial, Mr. Bennett and I will ask you to find the defendant guilty of attempted murder and guilty of possession of a weapon for unlawful purpose. Thank you, Judge.
Thank you, Mr. Shellhorn.
Okay, so that's it.
I will turn now to the defense opening.
All right, that's it for the state opening. It's pretty straightforward. I mean, the state's narrative is not complicated. This guy pointed a gun at people and shot them, from which we can infer an intent to kill. It's a miracle they survived, so it's only attempted murder charges, not murder charges. He did it out of anger, out of rage, without legal justification, and therefore you should find him guilty of attempted murder. So the execution of that opening statement certainly could have been much better, especially at the start. Thankfully, he kept it reasonably brief to only about 20 minutes or so, which is always nice. Yeah, the lawyer looks like he's about 12 to me. He's probably 30, but that's the way such things go. And all the scribbling, folks, that you're hearing is the judge. All the scribbling and the breathing and the clicking and the paper shuffling. That's all the judge doing that. All right, we're going to jump into the defense opening statement now. The defense opening statement is much more interesting because they have, on these facts, they have the tougher job. Remember, when you're arguing any kind of justification, you're not saying it wasn't me. You're saying it was me, but I have some justification or excuse. So in this case, the justification would be self-defense, and it doesn't get very much emphasis from the defense in opening. And the excuse they're seeking would be some form of insanity defense. Insanity defense is a pretty technical defense. It varies a lot from state to state, where the burden is, the specific criteria that have to be met. But generally speaking, you have to have really not known that you were shooting another human being. You thought you were shooting a space alien or some inanimate object or a robot or something that was not human. If you knew you were shooting a human, well, then you were not sufficiently insane. You knew what you were doing was wrong then, because it's wrong to shoot a human without appropriate justification. So what the insanity defense can do for you, if successful, is so instead of leading to a guilty verdict where you'd be sentenced to prison, it leads to a verdict of you're still not. It's kind of an acquittal, but it's an acquittal that puts your life in the hands of the court. And normally in this kind of case, you would find yourself institutionalized until doctors for some indeterminate period of time. So at least a prison sentence is some usually reasonably definite period of time, or at least a range. The institutionalization can theoretically be forever until doctors decide that you're no longer a threat to society. That could be a short period of time. You regain your sanity, or they could decide you never have regained your sanity to the point where you'd be safe to relief, and then you're institutionalized forever. In a setting that is presumably more pleasant than prison, but nevertheless, that's what an insanity finding gets you, is not freedom, but institutionalization. But before I jump into the defense opening statement, I do want to mention, this time I've remembered, our sponsor of today's content, which is CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. I can assure you that Michael Barisone's legal defense here is costing him a fortune, certainly hundreds of thousands of dollars, because that's how expensive these cases get. If all you do is make someone aware that you have a gun on your person for the purpose of changing their behavior, you've checked all the boxes for a charge of felony aggravated assault with a firearm, which is good for 10 to 20 years in prison if you're convicted. And when you retain your lead counsel, they'll be asking for a retainer in the range of $30,000 to $50,000 for pre-trial work, folks. That doesn't cover a trial. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family against criminal aggression, it can be helpful to have a legal partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because really, it does depend on it. We'd all like to think we live in a world where how many resources you bring to the legal fight doesn't affect the kind of justice you get, but I assure you that it does. Now, I've looked at all the companies that offer this kind of service, as you might imagine, and I have found that by far CCW Safe was the best fit for me. Personally, I'm a member of CCW Safe. My wife, Emily, is a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can save 10% off the first year of your membership using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. So take a look, folks. They're really a great organization. I think the world of them. They do more than just provide money. They have a investigative team that they fly in to the scene of the event. It's staffed by career police homicide detectives, by Don West, their national trial counsel, who was one of the defense attorneys for George Zimmerman, a world-class criminal defense attorney. It is an unbelievable team of people that they bring to your defense, as well as the money. So I would urge you to take a look at what they have to offer. Again, at lawofselfdefense.com/CCW Safe. Okay, let's pull up the state opening. Now, the defense opening. The state opening was about 20 minutes. Gratefully so. The defense opening is about twice that long. You'll notice how much more effectively the defense opens than the state did. The state opened with the address of the horse farm where the event took place and a description of, well, there was a building here and a building there, and this building had a hallway. And if you go down the hallway and look at the walls, you'll see awards to the defendant for horse riding. And I mean, stuff that's really not compelling, doesn't humanize the case for the jury, doesn't tell them why they're there, what the expectations are, what they'll be asked to do, why this opening statement is starting this way. The defense does a much better job opening their statement. Of course, they are stuck with some tough facts that their client shot these two people without much apparent justification. And as we go through the 40 minutes or so of the defense opening, you'll see that they spend almost no time talking about self-defense. They mention it very briefly in passing late in the opening statement. If this were a genuine self-defense case, they'd be talking about nothing else but that. This seems to be more of a case where this man was driven beyond his limits, broke, and shot these people without justification. but not quite to the point of insanity. So betwixt and between self-defense on the one hand and an insanity defense on the others, that's what this defense attorney is going to talk about. How much the victims in this case pushed the buttons deliberately, knowing what they were doing, driving him batty, posting on social media inflammatory content, pages and pages of it, without relent, taping apparently his private conversations and sharing that on social media. Threatening him with all kinds of legal action, false accusations of child molestation. I mean, just horrible, horrible stuff. These were not nice people by all accounts. And I don't think the state's going to dispute that, because I think the defense has it all on Facebook posts. I think it's all in evidence. But of course, being a terrible, horrible person doesn't mean the person you're being horrible and terrible to can shoot you for that. Words alone, however horrible, are not by themselves sufficient to justify a use of defensive force. There has to be some actual threat, and evidence of that actual imminent threat in the moment these shots were fired is pretty thin on the ground, as we'll see. Even when the defense describes the purported physical threat to the defendant, it's very ambiguously described. It's not a clear statement of the defendant, our client, was facing this threat, and that's why he fired those shots. It's kind of ambiguously suggested, but the timing is unclear. For example, they'll say that the defendant took a beating from this woman's boyfriend, but they don't say the beating was what triggered, so to speak, the shooting. I expect we'll learn that the beating was actually subsequent to the shooting, in which case the state will argue that, well, sure, the boyfriend was physically beating him. He just shot the girlfriend, and he was trying to prevent further. He was acting in self-defense in beating him. They'll say the woman's dog attacked the woman victim. Her dog attacked this defendant. We'll see pictures of the bites. But if that happened after the shooting, the dog was just acting in defense of its owner. So we'll have to see how that goes. But what I hear from the defense here in their opening statement is not a strong argument of self-defense, which is why I probably will not be covering this trial in the minute detail we did for Rittenhouse and Curtis Reeves and Kim Potter and so forth. This may be a they needed killing defense, which might have a far better reception by a jury in Texas or Oklahoma than you can expect in New Jersey. That's the way it works. All right, let me pull up this defense opening. Okay, here we go. And again, folks, before I do open it, if you could please smash that subscribe button. We're within less than 200 people of hitting 30,000 subscribers. That would be greatly appreciated. If you could hit that like button, hit the bell to get notifications, leave a comment, because that fools the YouTube algorithm into spreading word of our events. I mentioned earlier how YouTube has actually given my morning live show from today, demonetized it because I used 45 seconds of the video of Will Smith striking Chris Rock, the video that's everywhere on the internet, 45 seconds of it in an hour-long commentary and discussion and criticism of the event, which falls well within fair use, but that's what YouTube does to channels it doesn't like, folks. So if you could help us beat that down by subscribing, hitting like, hitting the bell, leaving a comment, that's always greatly appreciated. Thanks, folks. All right, so let me pull this up, and here we go. And the opening will be given by the lead defense counsel here on the left. Now, during the defense opening, the camera does pan back repeatedly to close-ups of the defendant, and you'll see him engaging in just odd behavior, grimacing, twitching, glancing around frantically, appearing as if he's in physical pain, emotional turmoil. I mean, maybe that's an act, and maybe he's just a broken human being, which certainly presenting the image of a broken human being would be helpful to the large bulk of the defense opening statement that their client, well, did this because the victims broke him. So here we go.
Thank you, Judge.
Thank you, Mr. Shellhorn. I will turn now to the defense opening.
Help. I'm in fear of my life. Help. I fear for my life. Someone, anyone, please help me. I'm in fear of my life. Those are the cries for help from Michael Barisone.
So I know this may come across as just silly theatrics, but this is what you need to do, folks. This is the defense attorney humanizing the client and the circumstances for the jury, building an emotional bridge between his defense of his client and that jury. The state opened with an address. This is much more effective.
Those cries fell on deaf ears. My name is Edward Belinkis. At counsel table, Christopher Deininger and I are charged with representing Michael Barisone. An awesome responsibility. Stop and think for a second of the magnitude. Presume, as the law requires, demands, that my client is innocent. If I get a little emotional, excited, I raise my voice, I mean no disrespect. I am the only thing standing between this man and a wrongful conviction. Me and the truth. I have his life in my hands. I accept that responsibility. On August 7th, 2019, Lauren Canreck was shot twice. A third bullet was discharged. Fortunately, it didn't hit anyone. Thank God she survived, is riding again, and living a normal life. It's a tragedy that Lauren Canreck was shot on that day. That said, there is another tragedy, a tragedy that will be played out in this courtroom. The tragic story of Michael Barisone, an Olympic athlete, a world-class dressage trainer, a man who on the outside appears strong, confident, in total control. But what the evidence will show, a much different picture. A man who had a horrible childhood, was physically abused by his mother, sexually molested by a neighbor over and over and over again. A man who left home to get away from all of that and found solitude, security in the equestrian community. A man who worked his way up to the top of the ladder, the top of his field, but behind the scenes was struggling.
So look here at this this defendant. Just watch his demeanor. I mean, he certainly comes across as a completely broken human being. And the defense lawyer now is reciting things from his childhood. Again, the victims are not responsible for molestation of this defendant when he was a youth. But the defense is trying to paint a picture, develop a narrative in which this defendant was perhaps exceptionally vulnerable to being broken by the toxic people he'll paint these victims as.
With anxiety, depression, suicidal thoughts, even delusions. You'll learn that for over a 20-year period prior to the shooting, he was seeing a therapist on and off. As the prosecutor said, he's now charged with 4 crimes. As the judge instructed you, the indictment is not evidence. And what brings this case before you? It's a vehicle to allow us to come up here and argue this case.
So the defense lawyer, either in the next few minutes or a bit later in his opening, is going to make a point that can be quite important, and that is this defendant got to trial because he went through a grand jury first. So a grand jury has indicted him, and that indictment has been shared with the jury. And you want to make sure the jury understands that because they might think, well, one jury's already believes this guy committed these crimes. That's why he's here. They returned an indictment. But of course, the way a grand jury works typically is that they only hear one side of the story. The prosecution is only required to tell the grand jury the prosecution's side of events. And if you only hear one side of a story, well, that side often sounds pretty compelling, only to fall apart like a house of cards once you hear the other side of the story. I mean, we've all had that experience just socially, right? Talking with families and friends who are involved in some kind of dispute. Sometimes a prosecutor will tell the jury both sides of the story. It happens relatively rarely. It happened in the Michael Brown hands up, don't shoot case. That prosecutor gave the grand jury all of the evidence, and the grand jury declined to return an indictment of Darren Wilson, the officer who shot Michael Brown. And frankly, it cost that prosecutor his job the next time he ran for election. And he'd been the prosecutor in that St. Louis jurisdiction for like 30 or 35 years. He'd been prosecutor there forever, for generations. But he made that decision to show the grand jury all the evidence. The grand jury refused to indict Officer Darren Wilson for shooting Michael Brown. And the next time that prosecutor had to run for office, a George Soros-funded candidate ran against him on the promise of reopening that case, which he never really did, but he ran on that promise and he won. So that prosecutor lost his career over that decision to show the grand jury both sides of the story. You think that sends a message to other prosecutors? It does. So here the defense attorney is going to just caution this trial jury that, hey, sure, an indictment was returned. That's not evidence of guilt. And in any case, keep in mind, the grand jury only heard the prosecutor's side of the story. We were not allowed to present our side of the story to the grand jury, which is certainly true.
That grand jury only heard one side, which I submit is going to be a lot different what all of you will hear in this courtroom. Defense wasn't there to question or challenge the state's case. You will learn, ladies and gentlemen, that the prosecutor's case is flawed. You will learn that they did little or no evidence with regards to what actually happened on August 7th. Worst off, they ignored what transpired prior to the shooting and are now trying to fill in the blanks after the fact. You will learn, ladies and gentlemen, that the prosecutor's only evidence will come from the testimony of the two alleged victims. Two people who have lied over and over and over again, left things out and changed their story. Their words after you hear the whole truth.
Well, all this is kind of deceptive, right? Because the evidence is not only from the two victims here. The victims were, the woman was shot in the chest. Those bullets came from somewhere. They came from the defendant's gun. That's evidence. So it's not like they lied that the defendant shot them. That's beyond dispute.
Will cast doubt on what happened, who attacked who, and who is the person that's responsible for this tragedy. It's the prosecutor's position that my client had a few problems with Lauren Canreck and her boyfriend. No big deal. Got angry, just drove down to the house and shot both of them. Shot her and shot at the boyfriend. That's not what the evidence is going to show. The fact will lead you to a far different conclusion. What the prosecutor didn't tell you, what this case is really about, It's about Lauren Canreck, her father and her boyfriend, devising a plan to destroy this man and drive him crazy. It's about the most devious attempt to destroy another human being.
So, of course, that all sounds horrible, but none of that would be a self-defense justification for shooting them. So for this defendant to be privileged to use deadly force in self-defense, he has to have been facing, at the moment he fired those shots, an imminent unlawful threat of death or serious bodily injury. The fact that they may have had some scheme to drive him nuts doesn't meet those elements required for self-defense. It makes them maybe horrible people. It makes them maybe that's a foundation for going for some kind of sympathy, compromise verdict on a lesser included offense for this defendant. But this is not a self-defense argument
That you will ever hear. It's about Lauren Canreck falsely accusing Michael Barisone of all sorts of misdeeds, criminal conduct even, and even the sexual abuse of his girlfriend's small child.
Look at the defendant here to the left.
And the whole time, ladies and gentlemen, the whole time she's doing this, knowing how her personal attacks were adversely affecting this man and getting pleasure, amusement, even thinking it was funny at him deteriorating. Every man, woman has a breaking point. Some people are stronger than others.
Shooting someone because they pushed you past your breaking point is not a justification of defense, folks. That's not self-defense. It might mitigate what would have been murder to manslaughter, but it's not a self-defense justification.
That, ladies and gentlemen, is really what this case is about. So there's no misunderstanding what my defense is. I'm not going to leave anything out in this opening statement. My client is not guilty. At the time of the shooting, my client feared for his life. He was suffering from a mental disease and did not know what he was doing was wrong.
So he's conflating self-defense and some kind of insanity defense here. So that's literally the insanity defense. My client did not know what he was doing was wrong. He did not know he was shooting a human being. That would be the insanity defense. The self-defense would be my client believed he was in jeopardy of death or serious bodily injury. But for that to qualify for self-defense purposes, yes, you need to have that subjective, genuine, good faith belief that you're being threatened with imminent death or serious bodily injury. But that belief also has to be objectively reasonable. An irrational, insane belief that you need to use deadly defensive force, that fails the element of reasonableness and fails self-defense. And by the way, folks, when I say element of reasonableness, if you don't know what I'm talking about, we have a free infographic. There's 5 elements to any claim of self-defense, up to 5, sometimes not even 5. But at most, there's 5. These are the building blocks of every claim of self-defense, no matter what state you may happen to be in. And we make this is a printed one, of course, but we make this available for free as a downloadable PDF infographic that I encourage all of you to get. It lists the 5 elements of self-defense. They are innocence, imminence, proportionality, avoidance, and reasonableness. It provides a brief description of those. And you can get that at the following URL for free, folks. We don't charge a penny for this. You can get this downloadable PDF infographic at lawofselfdefense.com/elements. If you don't know these 5 elements, you can't possibly understand self-defense law, or more importantly, you can't possibly know whether or not your use of defensive force against some threat and danger would be lawful or would put you in prison for much of the rest of your life. So if you do nothing else, I urge you to take advantage of that downloadable, free, 100% free, not a penny, free downloadable infographic at lawofselfdefense.com/elements. And even better, you might consider taking advantage of our offer to get a free copy of our best-selling book, The Law of Self-Defense Principles. You can buy this book at Amazon, folks, and they'll charge you for the book. I think it's $20 or $25 plus shipping and handling. I do encourage you to go to Amazon. You can look at the reviews of the book. There's well over 1,000 reviews. We're a 5-star rated book, the highest rating. But don't buy it there. We'll give you the book for free. We just ask that you cover the cost of shipping the book to you and the cost of our warehouse guys packaging up the book for shipment. So we ask that you pay the shipping and handling. It's $8 or $9, but we'll eat the cost of the book. And you can get that at lawofselfdefense.com/free book. Not that hard to remember. Get it for yourself, get it for friends, whatever. But this translates all the legalese of self-defense law into plain English. Most people can read it in an afternoon. And then you'll know about 80% of what I know about self-defense law, which is not bad for an afternoon's work. I can assure you it took me far longer than an afternoon to acquire the expertise myself. All right, back to the defense opening.
That concept of purposefulness that the prosecutor talked about. Under the law, our society recognizes that some people may be bad and some people may be sick. The law recognizes that a hostile act may result from some infirmity or sickness of the mind which an individual did not design. It is society's judgment, which is recognized by our law, the law that all of you have been sworn to protect, that a forbidden act should not be punished criminally unless done with a knowledge of wrongdoing. It's important that all of you know at this point, and the judge will instruct you as to the law at the end of the case, but it's important that you know that if a person is found not guilty by reason of insanity, that person will be not freed or indefinitely committed to a mental institution. The court will hold hearings, make determinations that provide for that individual, but also provide to protect the public.
So obviously, this is an explicit call to the insanity defense, and he's just assuring the jury that, listen, you can find my client not guilty by reason of insanity and not be worried that he's going to be released on society. You can believe he's dangerous, still find him not guilty by reason of insanity. Don't worry, the judge will institutionalize him for the safety of society.
Let's look at the evidence. Michael Barisone owned 2 stables, one in New Jersey, one in Florida. Lauren Canreck and her father make a deal to board and train their horses at Michael Barisone's company. Barisone agrees to train Canreck and her horses, and also, and this becomes important, agrees to give her living accommodation. At first, things go all right. Then a problem develops between Canreck, Barisone, and his girlfriend, Mary Haskins Gray. Now, I'm sure Lauren Canreck is going to take that stand and give her side of the story and try to blame other people for whatever issues arose. However, you will see Lauren Canreck's social media posts that will tell the real story, the scary story. You will learn that Canreck becomes obsessed with Mary Haskins and blames her for all her shortcomings. She believes that Mary Haskins, his girlfriend, is trying to destroy her life, her livelihood, and her riding career. You'll learn that she starts causing problems at the stables. She starts bad-mouthing Barisone, Mary Haskins, and the staff members. She starts posting on social media for the world to see disparaging remarks, attacking them and their business. You'll learn that she tells people, which Barisone sees on these posts, that he abuses and neglects horses. In the equestrian community, that is a death knell, obviously. That he's a deadbeat. He doesn't pay his bills. She even calls him a criminal and accuses him of insurance fraud. And then she starts
So, of course, all these terrible accusations, we would have no idea if those things are true or not, right? I don't have any personal knowledge of these facts. And if we assume that they're not true, that they're complete falsifications, this is terrible stuff to do to someone. Terrible to do this to this defendant. I mean, it could be career and life destroying for him on every level. It's still not a justification for the use of deadly force against the victims.
alleging on social media that she has been bullied and that her life has been threatened. And you'll learn that all these things are false. They never happened. Because of those attacks, Michael Barisone starts looking into Lauren Canreck and her boyfriend. They call numerous people in the business. And the equestrian community is a small, close-knit community. She's told various things about Goodwin and Canreck. He's given names of people. Him and Mary Haskins call these people and talk to them. You will see the true Lauren Canreck in these posts, and you will see why Michael Barisone becomes afraid of her. What the evidence will show is that at some point, as early as 2018, she's told if she doesn't like it here, to leave. You don't like the way you train, you don't like this, you don't like that, leave. She refuses.
So the defense is going to characterize the victim here, the female victim, Lauren Canreck, as basically a horrible witch of a human being who's deliberately torturing this guy into insanity. And that could all be true. And it's still not a basis for the use of deadly defensive force by this defendant. You can't shoot witches for being witches.
See, at some point, she starts ramping up her social media attack, starts posting threatening things on Facebook. You'll learn that Michael Barisone, his girlfriend, and other staff members start pulling up her Facebook posts and looking about what she's posting. They see postings of her talking incessantly about guns, carrying guns, sleeping with a 9mm under her pillow. They see posts of her saying that she's being bullied by a 6'3" man and that she's afraid of this person. She talks incessantly about going to war. It's time. War is inevitable. She said things like, weapons hot. After Barisone sees these posts, he contacts the father and basically says, this can't go on. She has to leave. It's important to note at this point, when all these crazy things are going on, when all these posts, threatening posts, are occurring, she is living above Michael Barisone in his house in an upper apartment with her boyfriend.
So I hadn't actually caught that earlier. I had missed that. I had presumed she and her boyfriend were living in a second house somewhere on the property. Uh, these unbelievably toxic people, apparently attempting to destroy this guy's life, were actually living above his head in the same home. Imagine. And folks, he can tell them to leave, but if that's where they live, it's an eviction process, and they could not be paying rent or not be doing anything or whatever. And it's a months long process, and every lever in the criminal justice system is designed to favor them, not the property owner, because the court's interest is in not having people become homeless. That's it. So they can tell him to go to court, get us kicked out if you can, and then the burden's entirely on him. Now, eventually, you may be successful after a year and a half, but that's how long it takes. And in the meantime, they are torturing him. Again, unfortunately for him, not grounds for the use of deadly defensive force.
The evidence will show that once these posts are pulled up, everybody is digging into Lauren Canreck's Facebook post. You'll find, or they find, Michael Barisone finds a post where Lauren Canreck threatened to kill both her and Mary Haskins and destroy his business. You'll see the
I see someone in the comments saying, why didn't he just change the locks? If you take steps like that to keep the tenant out, you are legally liable. You turn off their hot water, you think you're being clever, you are legally liable. Turn off their heat, you are legally liable. The courts have run into this problem before, and they've dealt with the property owner harshly.
post. Although she uses metaphors, it will be clear who she's talking about and what her intentions are. You will learn that after Michael Barisone sees this post, he flees his own home, his castle. He takes his family, the girlfriend, and a small child, and leaves that.
So it's his home, it's his castle, right? I would certainly agree. It's his castle. Here's the problem. By inviting other people in that home to live there, he's made it their castle too.
That farmhouse and flees to the stable area. He is now sleeping on a couch, living out of a suitcase in the club area.
Sounds like a bad marriage.
There'll be evidence to clearly indicate that Michael Barisone is afraid. He's scared. You'll see evidence, ladies and gentlemen, that on July 31st, he hires a private security. You'll learn that they ran a background check and gave it to Barisone.
You have to listen to this private security he hired. I mean, this is how desperate this guy was.
That same night, on July 31st, approximately a week before the shooting, Barisone, his girlfriend, and other people are up at the stable area, and numerous people hear Lauren Canreck screaming that she is going to destroy everything in Mary Haskins' life, everything she loves and holds dear. Upon hearing that threat, Michael Barisone calls 911. Washington Township responds. He says, I am in fear of my life of this woman. The police do nothing. Barisone tries to show him the paperwork, the background check that he got, the threatening post. It's a civil matter. They do nothing.
Well, it is a civil matter. The police are not your personal enforcers of your preferences. If there's an actual law, criminal law being broken, That's where the police step in. If they have a warrant from an order from a court to do something, that's where the police step in. Absent probable cause of a crime being committed or an order from a court, it's up to you to take people to civil court.
The next day,
So it's true, though, the woman victim here posted threatening kinds of stuff online, but it was rather ambiguous theatrical stuff, like "we're going to war, I will destroy you." None of them were things that would qualify as an imminent threat of harm at the moment this defendant fired the shots. Now, keep in mind, prior threats can be relevant to support a reasonable perception of an imminent threat in the moment you shoot. But what's still required is that imminent threat in the moment you shoot. If you're claiming that there was an imminent threat in the moment I shot, you can articulate that and you can say, hey, it's not only the moment that led me to that belief, it's all this other stuff too, all these prior threats too. That's all relevant to your perception of the imminent threat. But there has to be the imminent threat. All that prior stuff only matters in the context of an imminent threat. If there's not an imminent threat at the moment you fire the shots, all the prior stuff doesn't matter. And here there's little or no apparent evidence of an imminent threat at the moment he fired the shots.
August 1st, Barisone starts calling people to get help. He calls the general counsel, who he knows, of the United States Equestrian Federation. He
Look
calls
at the defendant here.
CEO of the United States Equestrian Federation, the agency the prosecutor talked about. He calls the police officer, who's a friend of his, and telling them what's going on. You'll learn on that day, August 1st, Lauren Canreck comes to the stables. She comes after hours, after the stables are closed.
I mean,
And
either
again,
he's
she's
really
now coming after
broken,
hours
this
to
defendant,
the
or
stables,
his lawyers put
which has
Satan
become
peppers in his underwear.
Michael
One or the other.
Barisone's last refuge of safety. She's told to leave by the owner of the property. She refuses, she flips out. Michael Barisone calls 911 again for the second time. They come, Washington Township. I am in fear of my life. Nothing.
So you see this sometimes where defendants will say what they think are magic words to the police. And maybe it's true. I mean, maybe they have a subjective fear for their life. Sometimes it's obviously orchestrated. You'll have defendants taking a video of themselves saying, I'm in fear of my life. I'm standing my ground. Castle doctrine, all this kind of stuff, as if saying the magic words by itself creates a justification for their use of force. It doesn't. You may have heard that you need to be able to articulate why you used force against another person, and you do. So you do need to say the words, but that articulation has to be based on evidence, folks. The words absent evidence to support them are worthless in terms of a legal defense. So, all right, you were in fear for your life. That's a subjective state of mind. Why? What evidence were you looking at from which you inferred that you should have a fear for your life? How was that perception, even if true, objectively reasonable because it's based on evidence? Just saying the words that does not do it, folks. By the way, I should mention, I saw a number of people in the comments mention the hardcover version of our book, The Law of Self-Defense Principles. Of course, I don't have a copy with an easy reach. It's been our practice in the past to autograph every single one of those hardcover books. So for everyone who ordered one, you got an autographed copy. I should mention we're stopping that because it just got to be too burdensome. The warehouse still has some autographed copies sitting there. So until they run out, everyone who orders a hardcover will be getting an autographed copy. but there's only a few dozen of those left. And after that, the hardcovers are not autographed automatically, folks. Sorry. If we ever meet in person, bring your book. I'll be happy to sign it. No charge, of course. But if you're interested in an autographed hard copy and we're not likely to meet in person, you might consider ordering one sooner rather than later. Not promising yours will be autographed. It depends on when they run out, and I'm not keeping track of that. But once the autographed ones are gone from the warehouse, they're gone. So if you're interested in a hardcover copy of The Law of Self-Defense Principles, our best-selling book, you can get that at lawofselfdefense.com/gethard. Okay, folks. Sorry, just wanted to mention that.
What's interesting on that day, August 1st, is that Washington Township calls the Morris County Prosecutor's Office and talk about what's going on. And after that discussion, the police officer tells both Barisone and Lauren Canreck, "Mr. Barisone, you can't restrict her movement on your farm. She could come and go whenever, wherever she wants."
And that's a true statement of the law, by the way. So here, the cops have been called out to this property because these two groups of people just can't get along. And there's no crime being committed. There's no court orders. There's nothing for the cops to do here. And yet they keep getting these 911 calls, somebody screaming, Barisone, that he's in fear for his life. So they race out there and there's nothing for them to do. They're tired of it. So they got so tired of it, they finally called the local prosecutor's office and said, "Hey, is there something we should be doing here? I mean, these people are crazy." And the prosecutor told them, well, tell Barisone he took this woman in as a tenant. He can't restrict her access to the property. She's there as a tenant and to horse train. He gave her license to the entire training facility. He can't now arbitrarily withdraw that. She cannot restrict her movements. And he gave her a room in his house, so he can't even restrict her out of the house. That's just a statement of the law. You may not like the law. I don't much like it, but that's the way it is. And what did the police then, after speaking to the prosecutors, tell Lauren Canreck?
You'll learn that they gave Lauren Canreck free reign of the property, including his now residence. Michael Barisone is so afraid. He has no idea what to do, how to protect himself. He hires a private security guard and pays him $100 a night to sit in front of the stables with his truck pointed towards the farmhouse where Canreck and her boyfriend are living.
So this is his private security guard. He's paying to stay up all night in front of his house. He's paying him $100 a night. Folks, in New Jersey, that's like minimum wage. I mean, a kid delivering pizza is making more than $100 a night. It's what kind of security guard do you think he got? Really, not somebody armed and licensed under New Jersey law to be a security guard.
Guard them.
Not at that rate.
You'll learn that Barisone is not sleeping at this point. He's walking the property at all hours of the night, trying to protect his family, the people who work there, the horses.
And it may be true he was not sleeping. And by the way, not sleeping, you don't sleep long enough and you become psychotic. So not sleeping could have contributed to a latent instability aggravated by this horrible treatment by the tenant and the boyfriend, and then his own response by not sleeping. And I mean, it looks like a mental death spiral to me, but again, not justification for the use of deadly defensive force.
You'll learn he is so afraid on the next day, August 2nd, 5 days before the shooting, he and Mary Haskins send her son home, 11-year-old son. They send him back to the father because they're concerned about his safety.
Yeah, sorry, guys. The battery alert is in the recording, so my computer's not about to die. My laptop that was recording this was about to die, but it did make it to the end, fortunately.
You learn that Barisone's trying to get some evidence or something to convince the police that Canreck should not be there. You learn on that night, he checks their trash and finds Suboxone, empties Suboxone packages in Canreck's trash. Suboxone is a drug used by heroin addicts. You'll learn on the next day, August 3rd, Canreck is still posting crazy things after she has been told to leave. You'll learn at that point, around August 3rd, Michael Barisone has a feeling or thinks he's being recorded.
Okay, so I'll just pause it here to note that we're more than halfway through the defense opening statement, and they've yet to mention anything that would substantively support a claim of self-defense justification for this use of force. Halfway through, not one fact claimed that would support the use of deadly defensive force here. Now, they do get to a little bit of that, but I'm just emphasizing how little weight they put on this themselves and how much weight, comparatively speaking, they put on this mental instability, the hostile treatment, the lack of sleep, and explicitly mentioning insanity defense.
Private conversations that he's having with his girlfriend and other people at the stable start being posted or texted or used in conversation. You'll learn that on that day, Lauren Canreck posts a post and basically says, I have multiple personalities and I am not responsible for my actions. Barisone sees that post. He calls 911 again, a third time. I am in fear of my life. He also tells the police that he thinks he's being recorded. They do nothing. What they do, unbeknownst to Michael Barisone, is that they go and talk to Lauren Canreck. And what will become important when you're judging someone's credibility is that on that day, Lauren Canreck tells the police that she's recorded Barisone and the staff. The police do nothing. They conduct no investigation, and worst of all, they don't go and tell Michael Barisone, this woman's recording your private conversations. They just leave the property. On the 4th, 3 days before the shooting, Canreck is posting crazy texts to Michael Barisone. After she's told to leave, she's texting him that she's going to send people that he doesn't know onto his property, into his stable to ride her horses. She also said she's going to put elderly people or infants in his house.
So she sounds just horrible, doesn't she? I mean, she's really just torturing this guy completely.
Know what to do. He calls his lawyer. The lawyer says, if anyone comes on the property, you need releases. On that day, Canreck comes to the stable again. Barisone tells her, you must sign a release. She flips out, makes threatening remarks. Barisone calls the police, 911, again, for the 4th time. I am in fear of my life. Again, the police do nothing. On August 5th, Canreck is posting, texting things using the exact words that Michael Barisone and others used in private conversations. He hires a debugging company. He has no idea where this is coming from, how she's recording him. He pays that debugging company $5,000 to come in and sweep the areas.
They find nothing.
They don't find anything. But you'll see a post where Lauren Canreck boasts about putting the devices where no one can find them. The evidence will show, ladies and gentlemen, that with regards to Barisone thinking in his mind that his private conversations were being recorded, that Lauren Canreck, her father, and the boyfriend were secretly recording numerous conversations.
All that paper shuffling is
We
the
have
judge,
over
folks.
70 private conversations that they recorded in the residence, the stable, the club area, which became his residence, and even his private office. What's worse, not only is Canreck illegally recording Michael Barisone, she starts using those recordings to taunt him, to push him over the edge. She's posting for everyone to see private conversations. You'll see in one of those postings that Barisone saw that she says she thinks it's funny watching them scurry around trying to have a conversation. Well, that's not all. For that day, Michael Barisone has his lawyer send Canreck a letter, a 3-page letter, laying everything out, saying, get out. Because Barisone knew that his lawyer had sent that letter, he was concerned for his safety. He personally went to the Washington Township Police Department with stacks of papers and whatever evidence he had accumulated at this point to try to plead with them for help. He doesn't even get into the back. 3 officers come out and basically say, get out of here.
He doesn't even get to the back of the police station. The police have zero interest in this. This is still a civil issue between presumably grown adults who are acting like horrible children. There's no crime here. There's no court order for them to enforce. There's nothing here for the police to do. And they're not going to spend a couple hours with an apparent lunatic in the back of the police station going over his 1,000 pieces of paper.
You know, we've been to your house. We told you we can't do anything here. And they push him out of the office. They don't look at anything. On the 6th, the day before the shooting, Canreck, after she gets that letter to get out, ramps up her attacks even further. She posts a 3-page post falsely accusing Barisone and Haskins of various untrue things. She even puts in those posts for everyone to see the private conversation on that day.
Folks, for everyone in the comments saying he should have gotten an order of protection, for what? For her being mean? She's not threatening him with physical harm. Not in any imminent sense. She certainly has not attacked him. And a landlord can't get rid of a tenant simply by going to the court and asking for an order of protection against that person. That's just not how this works.
The 6th, the day before the shooting, after the letter on the 5th, Canreck is served with a formal eviction notice. You'll learn that things get even worse for Barisone.
So only now, a day or two before the shooting event, is Canreck served with a formal eviction notice. Well, she gets to contest that eviction notice. So, I mean, only now is the clock on that running. The months and months of eviction contestation hasn't even begun.
You'll learn that Canreck and Goodwin filed a complaint with the town saying that Barisone was doing construction in the house and stable with no permits, and they made an allegation that both locations were unsafe to habitate. What you'll also learn is that Lauren Canreck's boyfriend, the one who made the complaint with Canreck, was the one doing the work.
So this is where Canreck called the township. It's Washington Township. I don't know what county in New Jersey that is, but it's Washington Township. She calls the township and says, "Hey, there's all kinds of code violations. There's work being done without permits." And then the township comes out, and sure enough, it looks like all that's happening. So they shut everything down, basically kicked this guy out of his own house, to the point where he's sleeping in a mattress on the front porch. I mean, that's how extreme this has all gotten at this point.
You'll learn that on the 6th, the town comes to Barisone's statement in New Jersey. They kick him out of his last place of refuge. He is now sleeping on a mattress outside on a porch in front of the stables. He is now virtually homeless.
So now we're 3/4 of the way through this opening statement, and well, 2/3 of the way, I guess. Still no explicit, substantive facts offered in support of a reasonable perception of an imminent threat of deadly force harm when he fired those shots. Lots of talk about people being mean, conspiring to drive this guy crazy, this guy being driven crazy, but no evidence yet claimed. And again, it's an opening statement. It doesn't have to be proved, but they're not even claiming evidence yet that would support a justified use of deadly force in defense against these victims.
You'll learn the whole time the town was there, and they came in mass. Fire protection, health department, building. Robert Goodwin was there pointing out everything to make sure Barisone would get kicked out of the residence. You'll see how upset Barisone was. And Goodwin saw how upset Barisone was. At one point when the town is there, after he's been kicked out of his stable area and is living on the front porch, Robert Goodwin, when their backs are turned to him, takes his finger, makes it in the shape of a gun, pulls the trigger, and mouths the word to Michael Barisone, "Get ready."
And if they had shown up and conducted themselves as if they were about to shoot him, that conduct would be relevant to come to a reasonable inference that they were about to shoot him. But there still has to be the ultimate imminent threat at the end. The gesture earlier by itself is not enough to justify the use of deadly defensive force.
You learn that even that wasn't enough for them. Lauren Canreck wasn't even satisfied with that type of destructive behavior. You'll learn on the day of the shooting, August 7th, she posts another threatening post. She's talking and telling the world that she has eyes and ears in places that can't ever be detected. She talks about having fun watching them. You'll learn that on the morning of the shooting, Robert Goodwin, the boyfriend, and the blacksmith have a problem, an argument. The blacksmith doesn't want to shoe their horses anymore because of what's going on at the stables. You'll learn that he blames Michael Barisone and makes a threat. There's going to be consequences. The day after he uses the finger gesture. That statement was relayed to Barisone. It's not over yet. There'll be more evidence. And you will learn, ladies and gentlemen, that Lauren Canreck set in motion the final, what I call the coup de grace. She did the worst thing any human being could do to another human being. She falsely accused him of sexual misconduct with his girlfriend's son. As the prosecutor said, on the 7th, DCPP Dyfus shows up and confronts both Barisone and Haskell. She's really not supposed to tell anybody anything with regards to her investigation, but you will have evidence that Barisone was made aware of the allegations of sexual abuse. You'll learn at that point, after all that he had gone through and suffered, he starts to have a complete mental breakdown. You'll learn that from that point, he has no memory of what happened. Everything went black. Now, what the evidence will show is that Michael Barisone got into his truck, drove to the farmhouse. He's described, and the prosecutor said in his opening, angry, furious. This is how Robert Goodwin described him. Calm, sorrowful. Sorrowful. Not angry, not furious. According to Goodwin, Michael Barisone says, "Can't we work this out? I don't want to go to war." It's important that you know he uses the word that Canreck continually taunted him with. At which point, again, according to Goodwin, Goodwin says it's past that, talk to your attorney. Now, this is what happened, what the evidence will show. Robert Goodwin turns his back, walks away. Lauren Canreck then walks past Goodwin to
So this is the culminating confrontation where the shots are fired. So the defendant here has approached the boyfriend, said, "Can't we settle this? I don't want a war." The boyfriend said, "We're past that point. You need to talk to your lawyer." The boyfriend turns his back, walks away, and Lauren Canreck pushes past her boyfriend, walks past her boyfriend, approaches the defendant, and I guess is mean to him again. Still have yet to hear of any imminent unlawful use of force likely to cause death or grave bodily injury directed by these victims at this defendant that would justify his use of deadly defensive force. Well, we will hear a little bit of that ambiguously phrased by the defense attorney in just a few minutes.
confront Michael Barisone. They say Michael Barisone just fired 2 shots in her chest and 1 at Goodwin. What the evidence will show is that Michael Barisone was severely beaten by both Goodwin and Canreck.
Will the evidence show that? Maybe. He's very ambiguous. I don't believe the defense attorney ever actually says, and that's why he shot them, which makes me wonder if he wasn't just beaten by the boyfriend after the shots were fired. Why would you leave that out? If that's the reason your client fired the shots, aren't you going to explicitly state the reason your client fired the shots?
You'll see pictures of the horrific beating that this man took. Neither of them mentioned in their original statements that Canreck was involved in this beating. Neither of them mentioned that they had sicked their vicious dog on Michael Barisone. You'll see various bite marks over Barisone's body, including 1 vicious bite to the inner groin area.
And the bites could be true, but again, there's a lack of timing here, right? He's not saying he fired shots because he was getting bitten by the dog. That's not being claimed here. Why not? If that's why you shot, why won't you say that even in your own opening statement? Is it possible the dog bit him after He fired the shots. That's why he has the bites.
You'll learn when the police arrive. The Washington Township Police, the same people that had been there 4 times previously. You'll learn when the police arrive. They have no idea who the shooter is. Remember, Barisone's the one that said his life was in danger previously. You will learn, ladies and gentlemen,
That's the judge, folks. That's not me doing that coughing.
that when the police arrive there, they see Goodwin on top of Barisone beating the hell out of him. Neither of them have a gun in their hand. The gun is on the ground. They're rolling around.
Right.
You
So
will
this
hear-
is after the shooting. The police show up. The gun is on the ground. The defendant and the boyfriend are rolling around. Is that when the beating occurred? After the shots were fired? Because if so, that can't be the justification for the earlier shots fired.
Goodwin's voice in a 911 call. And although he'll claim that those statements were made after the shooting, you can get a sense of Robert Goodwin when you hear him say repeatedly over and over again, I am going to fucking kill you. Don't move. I'm going to fucking kill you. I'm going to kill you.
Again, if all this is being said after the shots were fired, they don't have any role in justifying the firing of the shots.
As I said, when the police arrive, they have no idea who the shooter is. The officer, the first officer on the scene.
For those asking, folks, generally speaking, the punishment for an attempted felony is the same as for the successfully completed felony. You're not getting a break because you failed in your attempt to carry through with the felony. So the punishment for attempted murder is normally the same as the identical degree of murder.
Ask the question, who's the shooter? Robert Goodwin, Michael Barisone. Case closed. You'll learn that Barisone was beaten so badly, so severely, he was in no condition to do or say anything in response to that question. You will hear evidence.
So this part of the opening now is kind of cover up for the fact that Barisone didn't say a word about self-defense at the time when the police arrived on the scene. And the lawyer is saying, he didn't say anything at the time, but that's because of the beating that he took.
With respect to the first officer who arrived on the scene, he describes Barisone as partially conscious. The second officer on the scene describes him as incoherent. The third officer recalls Barisone saying over and over again, "Is this real? I need to wake up." He tells all the medical personnel, the first aid people, EMS, Morristown Medical, and all the people at the hospital, when they're treating him, asking him what happened, he tells all of them, "I don't remember. I have no recollection of the event." You'll learn from the time DCPP arrived that he heard the allegation to the point when he woke up in the hospital, he has no memory of that event.
So for folks asking about cameras, we got about 4 minutes left in this closing. For those asking about cameras, there were some cameras up that were positioned to have captured this confrontation, but the police didn't collect the camera evidence, didn't think to ask for it for months. And by the time months went by, there was no footage on the cameras to collect. So that simply wasn't captured.
And there'll be testimony with regards to being caused by either the mental breakdown or the severe physical beating he took to his head. You'll learn that after Robert Goodwin points to Michael Barisone and said he's the shooter, they let him walk around. They don't do anything with him. You'll learn that there was a camera right above where this alleged attempted murder occurred.
Here we go.
Washington Township was aware of it that night. The Morris County Prosecutor's Office was aware of it that night. Goodwin says it would have captured the whole thing. You'll learn that Washington, like they had done in the past, and the prosecutor's office never seized that camera that night. They allowed the camera.
That's the judge
to stay
again,
in
folks, with the
possession of
papers. That's not
Goodwin
me.
and Canreck for months. And months later, when they finally put two to two together, they tried to download the information on the camera, but unfortunately, nothing was on it.
Folks, one of the reasons I like CCW Safe, why I partner with them a lot, why I'm a member of CCW Safe, why I recommend people at least take a look at what they have to offer, is one of the things that CCW Safe does is not just provide you with monetary resources for your legal battle and not just recommend an attorney for your criminal defense. They actually drop their own investigative team on the scene. These are people who are retired, experienced homicide detectives. They've done all this. They know what to look for, and they can make sure that exculpatory evidence is captured and not lost. The police themselves investigating this, they have no particular interest in going the extra mile to make sure that exculpatory evidence is captured. Nothing happens to them if the evidence is not collected or disappeared. Certainly the prosecutor's office has no interest in that. In a normal case, the criminal defendant, he's under arrest, waiting to talk to an attorney. He has no means of compelling the capture of exculpatory evidence or witnesses. So it's pretty darn helpful to have in effect, your own investigative team on the scene to make sure that's all done. And CCW Safe does that. That's part of their service.
You're going to hear from two highly trained experts, a psychiatrist and a psychologist, who's done a tremendous amount of work evaluating and testifying in hundreds and hundreds of cases for both the state and for defense cases. They don't just do work for one or the other, which I submit their credibility would be subject to attack. You'll learn that they did extensive, exhaustive evaluations of Michael Barisone. And in their expert opinion, at the time of the incident, Michael Barisone was suffering from a mental defect. And based on his delusions, he generally felt his life was in danger and needed to act in self-defense.
Okay, folks, so that statement right there is either insanity defense or at best imperfect self-defense. So a genuine good faith belief in the need, subjective belief in the need to use deadly force in self-defense. That's half of that element of reasonableness. But a subjective belief in the need to act in self-defense, no matter how genuine, no matter how much held in good faith, is not by itself enough to satisfy the requirements of that element of reasonableness. It must still be objectively reasonable. And he's not making that argument here, at least not based on any evidence. So if all you have is subjective, genuine, good faith fear, but it's not objectively reasonable, you don't have self-defense. You don't have an acquittal. You have at best imperfect self-defense that might mitigate the criminal conviction to some lesser degree.
And as a result of the mental illness, he was not aware of the nature and quality of his acts, and certainly didn't know right from wrong. Every man has a breaking point. And when you hear the evidence, you may not even need expert testimony. Finally, you will hear overwhelming evidence of the mental torture thrust upon this man, a man with prior mental issues. You'll learn about the exhaustive, the numerous steps he took to protect himself and his family. And you will hear from numerous people who saw him crumbling mentally to the point where they believed he was going to kill himself. Look at the evidence. More importantly, look at the lack of evidence. I submit with respect to the shooting, you won't know who did what.
So this whole lack of evidence argument is generally not compelling in a self-defense case. It's the kind of argument you make on behalf of a guilty defendant.
The only thing you will be certain of, after looking at all the events leading up to the shooting, coupled with Barisone's prior mental health issues, is that under the law, without question, Michael Barisone is not guilty. Thank you.
All right, thank you, Mr. Malinkas.
Okay. After this, by the way, the judge spoke to the jury and reminded them again that what was said in opening statements by either party is not evidence. There was some pre-discussion this day before the jury was brought in. The defense is trying to bring in all kinds of evidence about this orchestration of this emotional, mental torture of this defendant, all kinds of text messages between the victims and the father, and how they were chortling about how they were driving this guy crazy. And of course, the state is saying, well, how's that relevant to the defenses here? How's it relevant to the crime or to the legal defense of self-defense? And the judge remains unconvinced. He's undecided about whether or not he will admit that evidence so far, which is frankly ridiculous. I mean, the trial's begun, but he's obviously allowing the defense to talk about this stuff in opening statements and then simply reminding the jury that, hey, what's said in opening statements is not evidence. So just in case the judge doesn't allow that stuff in, well, that evidence obviously will never have appeared before the jury. So that is where we are in this case. So again, as I said at the start, it looks to me far more like an insanity defense, but I'm pretty sure this guy knew he was shooting a human being, which would normally put you outside the bounds of the insanity defense, or in an argument for imperfect self-defense, where you had a genuine subjective belief in the need to use defensive force, but that subjective belief was objectively unreasonable, in which case you fail the element of reasonableness. You therefore fail self-defense. There is no perfect self-defense. There is no acquittal based on self-defense. But imperfect self-defense may mitigate a more serious conviction to a lesser conviction. That can happen, and that may be what the defense is going for here, or to evince sympathy, to try to emotionally encourage jurors to maybe split the jury. So some are like, yeah, that was attempted murder. Or others are like, oh my God, what they did to this man was horrible. We can't agree to attempted murder under those conditions. So let's compromise on some lesser offense. May well be what they're going for here. But because it doesn't appear to me to really be a self-defense case, this is probably the limit of my coverage here, unless something dramatic happens. I just don't think there's going to be much about this case that involves actual self-defense as opposed to some kind of, mental disability. And those aren't cases I typically cover. Plus, I'd have to listen to this judge click his pen and shuffle his papers and clear his throat for a week or two. And given that it's not really a self-defense case, I'm not inclined to subject myself to that. But I did want to explain why I'm probably not going to cover the case in great detail. It's frankly because of these opening statements. Even in the defense barely made a mention of self-defense at all, not very compellingly, quite ambiguously. I don't think there's much there. All right, folks, with that said, it's been almost 2.5 hours. Hey, before you go, if you haven't yet, if you're new since I last mentioned it, hit that subscribe button. That would be greatly appreciated. Hit the like, thumbs up, leave a comment, tell your friends. We're within, I just looked, how close are we? Within less than 129 subscribers away from 30,000, folks. That would be fantastic to reach that. So if you can hit subscribe to help us get closer, that would be enormously appreciated. With that said, until next time, I'll just remind all of you that if you carry a gun in self-defense, so that you're hard to kill, that's why I carry a gun every day. So I'm hard to kill. My family is hard to kill. Then you also owe it to your family to make sure you know the law so you're hard to convict. And you can do that here at Law of Self-Defense. All right, folks, until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.